Good morning. The Senate Judiciary Committee will come to order. Thank you for joining, everyone. Committee, we do have a lot of business to get done today as best we can, so we're going to get started right away. Regarding Senate Bill 75, that committee worked on Thursday last week, and we got it out of committee favorably for passage. But however, and it has not been turned in or to the Senate as a whole, but I think there might be further motion or discussion on it. Senator Wilborn.
Thank you, Madam Chair. I would like to make a motion to reconsider Senate Bill 75. The conferees have come up with a little better solution, so I'd like to make that motion, please.
Thank you, Senator Wilborn. And if the reviser could spend a minute explaining the motion, or I can. Committee, if you'll remember, the Senate Bill 75 is about prejudgment interest, and in the hearing on the bill, we heard about tort claims, and there was discussion that the proponent of the bill had an amendment that would address the issue. And when we worked the bill on Thursday, the amendment was not brought up. So the motion to reconsider, if it passes, we would have the opportunity, if the amendment is brought up and seconded, to discuss that as well. So is there a second for the motion to reconsider the bill? Senator Gossage, thank you. Any discussion on the motion? Seeing none, you all have heard the motion. All those in favor signify by saying aye. Aye. All those opposed, no. The motion carries. Is there further discussion or amendments on the bill? Yes, Senator Wilborn.
Thank you, Madam Chair. Again, I do have an amendment. And
thank you. Could we get it passed out and an explanation from the reviser?
Yes, please.
Thank you.
I have right.
Ready? All right. Thank you, Madam Chairwoman. Jason Thompson, Revisor's Office. So SB 75, this is the balloon based on the testimony you were presented from the proponents. This would restore current law in subsection A so that creditors are allowed the 10% per annum rate when no other rate of interest is agreed upon. This would be contract matters, essentially. And then a new subsection B would provide what was in the bill, but for civil tort actions filed under Chapter 60, in which the court determines that prejudgment interest shall be awarded. And then in that case, the creditors will get a rate per annum of 2 points less than the rate specified in 16-204 E1, the same that was provided in the bill that was before you.
Would you like to move your amendment?
Yes, Madam Chair, I'd like to move my amendment.
Is there a second? Yes, Senator Gossage with the second. Committee, any discussion on the motion? Seeing none, yes, Senator Stephan.
Thank you. Okay, help me understand what's going on here. We spent a lot of time working on refining that language in like lines 7, 8, and 9, and now that's been struck, and we've gone back to this flat 10%, and this other balloon's showing up. I'm still trying to work through it. What's the rationale behind going back to 10%?
Senator
lines
Wilborn.
8 and 9.
Thank you, Madam Chairman. It's my understanding, Senator Stephan, that it is an agreement between the conferees to get to that point.
Follow
Senator, I think
that doesn't help me understand the reasoning behind it.
So let me offer this and see if this answers your question. Section 1 and current law it was understood by the conferees that it applies to contract actions, but not civil tort actions like malpractice or negligence, personal injury. And with the amendment adding in Section B to Section 1, that would put a cap on pre-judgment interest on civil claims, not contract claims. Civil tort claims, I'm sorry, not civil contract claims. Tort claims being, like I said, personal injury, negligence, malfeasance, instead of breach of contract issues.
Okay. Thank you. As a follow-up, because that does help very much differentiating the two, but I guess the question now is why should there be a difference between the two? What's the legal rationale for having a difference between those two scenarios?
Senator Wilburn, do you?
My only answer, and the chairman can weigh in, is that is what the conferees agreed upon. They wanted it separated. As far as the rationale, I cannot answer that.
I guess a follow-up, why are we not solving this on the floor of the Senate rather than bringing this bill back up like this? It really concerns me dramatically.
Actually, thank you for the question. This was the committee that heard the testimony on this. When we're on the floor, the body doesn't have the opportunity to consider the testimony that we did. And so it was the thought that actually it would be a more thorough vetting of it to hear it, a motion to reconsider here. And if the amendment gets on, the amendment gets on, and rather than the body as a whole. That had we had the opportunity to proceed on Thursday when this was first worked, instead of just an oversight that we didn't have an opportunity to work the amendment in committee, we are now having the opportunity to work the amendment in committee, which is the usual process when the amendment was discussed at the hearing in committee. Senator Baumgardner.
Thank you, Madam Chair. So we don't have any of the individuals, Eric Stafford and Carrie Silverman from the Kansas Chamber and the American Tort Reform, as well as Rex Sharp, who was an opponent. We don't have any of them with us. Is that correct?
That's correct. And generally, when we work a bill, we don't offer additional testimony.
And I understand that, Madam Chair, but I'm not seeing that the amendment we have before us is specifically what was asked. And maybe I'm just not seeing that in testimony.
It is, thank you for that. It is in page 2 of the Kansas Chamber testimony from February 8th. That was discussed at the hearing. If everyone, I can give you my copy if that's helpful. Committee, further discussion on the amendment. Yes, Senator Gossage.
Thank you, Madam Chair. And I do recall them saying that they were going to work together on an amendment. And I guess I thought that was already done and we already had it. So appreciate you bringing this to the committee.
Yes, thank you. And the amendment was discussed at the hearing. It's just when we worked the bill, it was just because of an oversight that the amendment wasn't brought up to be discussed. Further discussion on the motion on the amendment. Seeing none then, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Do we have any other amendments or a motion on the bill? What's the will of the committee regarding the bill as amended? Yes, Senator Wilborn.
Thank you, Madam Chair. I make a motion that we move out Senate Bill 75 as amended, favorable for passage.
Thank you. Is there a second? Senator Gossage. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. There's been a request for division. So all those in favor signify by raising your hand. Seeing 4. All those opposed signify by raising your hand. Seeing 2. The motion carries. Thank you, committee. We next will turn our attention to working Senate Bill 228, which modernizes statutes concerning county jails. And that is a bill that we heard, I believe, on Thursday of last week. So if you'll, committee document should be at your seat from that last week, and we'll have a brief bill brief from the reviser, please.
All right. Thank you again, Madam Chairwoman. So you'll recall Senate Bill 228 from Thursday. There's a whole lot of modernizing and updating language, but the core focus of the substantive changes that the conferees discussed were the amendments to 19-1927, allowing demolition or repurposing of jails that are no longer in use, in addition to what's allowed by current law, and then KSA 19-1930, requiring medical clearance for certain people in custody before they're admitted to the county jail. Those are the main provisions in there that are substantive.
Thank you. Committee, any discussion or amendments on the bill? Yes, Senator Gossage.
Madam Chair, I have an amendment if the reviser would pass it out.
Thank you. He will. Yes. Senator, did you want to explain your amendment or have the reviser?
I'd be happy to explain it. It's very simple. So we have, starting with line 23, each sex, female and male. We had a discussion in Health Committee this morning about those definitions getting rather muddy. And we also heard from various proponents from the prisons that there were, I believe, 44, if I have that number right now, biological males in women's prisons. This has become problematic, and they felt that some kind of a bill would be helpful to them. So that's why we have then the other balloon, which is on line 27. As used in this section, sex means the biological state of being female or male based on the individual's sex organs, chromosomes, and endogenous hormone profiles.
Thank you. Committee, Senator Gossage, would you like to make a motion on your amendments?
I move my amendment.
A second from Senator Baumgartner. Committee, discussion on the motion or the amendment. Seeing Senator Haley. Yes.
Thank you. I'm concerned or just wondering if there's some sort of change, I guess, in the status during the course. Thank you. And yeah, thank you. How would that then be classified if there's someone who's going through reassignment during the course of their incarceration? How would that or would that affect what the sheriff is required to do at that time if there is a reassignment during the course of incarceration?
Senator Gossage.
This definition is also used in a bill that we passed in health this morning, and that is that if one is going through transgender or going through transition right now, whether they were or weren't, biological male who just says I identify as putting on a dress, could, even those who've been sex offenders could now be placed in the women's prison. It's just protecting women. So I would say that this is pretty clear as to the definition. And then if there is something that's unclear, the prison would have to decide that. But this explains what sex means.
Thank you. Senator Haley, did you have further questions?
Thank you, Madam Chair, and thank Senator Gossage for explaining sex to me better.
Thank you. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Are there further discussion or amendments? Senator Wilborn.
Thank you, Madam Chair. I do have an amendment, and
Will the reviser pass it out? Would you like to explain your amendment or have the reviser?
the revised.
Thank you.
I do.
All right. Thank you again, Madam Chairwoman. So Senate Bill, let's see, the amendment to Senate Bill 228, it's labeled medical. The amendment's on page 3. This is in KSA 19-1930 that I mentioned in the brief discussion at the beginning. This is the one that talks about how the sheriff or the keeper of the jail has to take certain prisoners into custody when they're presented to them. And this adds new language that requires a medical exam to occur first for certain prisoners that present with a serious illness, a serious injury, or a serious impairment by alcohol or drugs or combination. The amendment would add in line 15, so it would strike in custody in line 15, and instead add who is in custody of an arresting agency, so that the sheriff or the keeper of the jail is not required to receive or detain a prisoner under this paragraph 1 right above it, who is in the custody of an arresting agency until the prisoner has been examined by a medical care facility, et cetera. So it clarifies that someone is brought in the custody of an arresting agency, and then the keeper or the sheriff will require a medical exam. And then in line 24, you add the provision, except as provided by 2 statutes in our criminal procedure code, the prisoner shall remain in the custody of the arresting agency during the examination that we just talked about, and the cost of that examination and treatment will be the financial responsibility of the prisoner. The 2 sections that are referenced there in the criminal procedure code already address who is responsible for the costs of medical treatment for prisoners, and deal with things such as the Medicaid rate and reimbursement by counties and which agency is responsible for it. So this just picks up the current law and makes clear that we're going to use those provisions and keep the person in the custody of the arresting agency until that exam is over, and then the jail would have their obligations kick in, and then the prisoner would remain responsible to the extent that they have insurance or coverage of some kind, just like they would under current law. So that's the attempt here with both of these amendments.
Thank you. Senator Wilborn.
Thank you, Madam Chair. I think this amendment just further clarifies some of the discussion that we had that very day on this issue. And this was an attempt by the law enforcement folks to make it very clear.
Thank you. Would you like to make a motion on your amendment?
Yes, Madam Chair, would like to move this amendment.
Is there a second? Yes, Senator Stephan. Committee discussion on the amendment. You all have heard, Senator Gossage.
I just want to say thank you to Senator Wilborn for this. It makes it much more clear from how it read before. Very clear who's in custody, very clear who's responsible. Thank you, and I'm in favor of this amendment.
Thank you. Committee, you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We're back on the bill. Further amendments? Seeing none then? Yes, Senator Baumgardner.
Thank you, Madam Chair. I do want to tell the committee I have an amendment. I have not had the time to work it out with our reviser. I did mention it during the hearing, and that is our county jails that are keeping individuals while they're awaiting being admitted to Larned, and they are not being compensated by the state. So because it's not prepared, and I understand the chair is wanting to move this out of committee, then all I can say is I will be working with the reviser for a floor amendment.
Thank you. And I would consider that a friendly amendment on the floor. So thank you for your work on that, Senator. Committee, you all, is there a motion on the bill as amended? Is Senator Wilborn.
Thank you again, Madam Chair. I'd like to make a motion to move Senate Bill 228 as amended out favorable for passage.
Is there a second? Senator Gossage. You all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we will now look at and work Senate Bill 193. That was heard last week. It's enacting the Reduce Armed Violence Act, Senate Bill 193. And if we could have a bill brief from the reviser.
Thank you again, Madam Chairwoman. So Senate Bill 193, you heard on February 15th or so. This is a bill that adds a new special sentencing rule in the sentencing grid for non-drug crimes, KSA 21-6804. The rule would provide that in addition to any other term of imprisonment you're subject to, if the trier of fact makes a finding beyond a reasonable doubt that you, as a person in criminal possession of a weapon by a convicted felon, possessed a firearm during that violation, and your firearm was possessed during the commission of a violent felony, you will have presumptive prison and consecutive terms of those punishments. And then violent felony is defined in the bill to include a number of crimes, and I won't go through the whole list.
Thank you. Any questions for the reviser? Yes, Senator Haley.
Excuse me. Thank you, Madam Chair. I'm supportive of the underlying bill and have been working to try and bring an amendment along this line or discussion. It's the sum and substance, I believe, of 183. I don't think that amendment is ready today, but I may want to bring it back up. What it does essentially is enhance the sentencing for those who shoot into an occupied house or shoot into an occupied car. And it enhances the sentence, underlying sentence. And I just wanted to make the committee aware that I may try on the floor, since I didn't know we were working those. I'll look to Mr. Thompson. We don't have that amendment. We didn't know. Who knew? Exactly. All right. Thank you.
Senator, if your amendment is the bill, if you want to discuss that.
Well, if there's going to be an opportunity to have it heard, I know that the schedule is running.
Oh, I mean, the schedule, we don't have time, but if you wanted your amendment to be the bill, if you wanted to discuss that.
In brief, Madam Chair, thank you. It 183, I believe it's 183. It just provides for what had been known as someone shooting into an occupied dwelling where they know or should have known that there was someone in the building, or into a car, an occupied car where they knew or should have known that they shot into the car. There's a further sentence enhancement if the shooter knew or should have known that a person under the age of 14 was in the respective house or car. And the long and short of it is there have been some cases where there's been random shooting into houses and into cars, and innocent people have been struck or injured. So this would enhance the underlying sentence for whatever crime was being perpetrated at the time because of that action on the part of the shooter.
Thank you. And committee, I've pulled up Senate Bill 183, and it is a 12-page bill. And since it's not in the form of an amendment, I'm not comfortable considering that as an amendment to the bill that we're working right now. So we're going to proceed unless there's a written amendment that we can see how it fits into 228.
I fully understand.
I'm sorry, 193. Thank you, Senator. Are there other amendments on Senate Bill 193 or discussions? Senator Baumgardner?
Well, the Senator Haley has indicated that he intends to bring this on the floor, so I just wanted to clarify. Is there a particular reason that you're saying individuals 14 years of age or younger why we're not making it 18 years of age or younger?
Madam Chair, Senator Baumgardner, there have been some heinous, tragic shootings or killings of children. I didn't know what the break, I mean, our statutory guidelines are often 14 for defining. But, I mean, what will be argued in some cases is that there could be a self-defense. There could be someone over the age of 14. There are some teens who are getting caught in a crossfire or what have you between houses and cars. But certainly we were trying to find the appropriate age when a child has been the victim of violence who had nothing to do with the whatever the altercation might be between the two. I don't know what the magic or how the magic number is 14. I've relied on the insight for the definition of child with in the crafting of this with the revisor.
Thank you, Madam Chair. I appreciate that.
Thank you. Committee, any other discussion on Senate Bill 193? Is there a motion on the bill? Senator Wilborn.
Thank you, Madam Chair. I make a motion that we move Senate Bill 93 out favorable for passage.
Senate Bill 193,
193
favorable for passage is the motion. Is there a second? I'm sorry, Senator Baumgardner, thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We will now turn our attention to working Senate Bill 238. Senate Bill 238, increasing criminal penalties on drug-related crimes when the drug is fentanyl. And that was a bill that committee also heard last week. If we could have a brief from the revisor.
Thank you again, Madam Chairwoman. So Senate Bill 238 does two things. First, it creates a special sentencing rule requiring mandatory imprisonment and some additional time for drug-related crimes when the drug is fentanyl. And second, it creates a special sentencing rule for drug crimes when the drug is attractive to minors because of its appearance or packaging. It also does a couple other things with the definition of manufacture to include placing them in pill or capsule form, and generally just increasing the penalties for unlawful manufacture or unlawful distribution of fentanyl. But the two major additions are the special sentencing rules that I outlined at the beginning.
Thank you. Committee discussion or amendments or a motion on the bill? Senator Baumgardner.
Thank you, Madam Chair. Are we going to be having a hearing today on Senate Bill 240?
Yes, after we finish working bills previously
I
heard.
was just curious if we were contemplating bundling these two.
That could be an idea. Just a moment. Let's stand at ease for a minute.
Thank you, Madam Chair.
All right. Thank you for your question, Senator Baumgardner. Appreciate that. And so we will put Senate Bill 238 into a position to still be worked, but we will cease our work on it today, and which then gives us an opportunity to work Senate Bill 174. You remember 174 increases the criminal penalties for the crime of interference with law enforcement when the violation involves fleeing from a law enforcement officer. If we could have a brief bill brief from the reviser on Senate Bill 174.
And thank you again, Madam Chairwoman. So Senate Bill 174 is the bill about the crime of interference with law enforcement, and it adds to the current law an increased penalty for knowingly fleeing from a law enforcement officer who has reason to stop the person after other than fleeing by operation of a motor vehicle. And you might recall that we have a separate statute for fleeing by a motor vehicle that has its own penalties, and that this conduct is currently covered by the law, but would have an enhanced penalty if you flee from a law enforcement officer, and it would go up to a severity level 7 in some cases, and a severity level 5 if a person has a firearm while fleeing.
Thank you, committee. I do have an amendment based on some of the discussions that we heard. And the reviser will please pass that out. Thank you. When we were hearing the bill about if you are fleeing on foot and you lawfully possess a firearm while fleeing, there was some concern that that shouldn't be considered against you. So the amendment is on page 2 of the bill at line 26. It changes possessed to discharged or used a firearm. So with that, I will move that we amend the bill as provided in the balloon sent out to you. Is there a second? A second, Senator Gossage and Senator Stephan with a question. Okay.
Thank you. Is there a definition for used in this situation?
Mr. Reviser, do we have a definition? I think the intent was you're either discharging it or, well, I'll ask the reviser.
Thank you, Madam Chairwoman. So I was looking for my notes from you, but that I made for you, and I can't access them right now thanks to the network. But the short answer is no, it is not explicitly defined, but it is used in several pieces of the criminal code and a couple of other special sentencing rules. It has a meaning within those special rules. In fact, there's actually a current firearm enhancement under the drug code that talks about an enhancement of presumptive imprisonment if you used a firearm in the commission of your drug crime. So it's not explicitly defined in the statute, but it has a meaning within the criminal code, and that's what we're relying on is used. And same with discharged. That has a general meaning that you would think of with discharge, but it's also used in other special sentencing rules already. So trying to use consistent terms was the goal of the amendment.
Thank you. Senator Stephan, further questions?
Yeah, so used to me would have to mean drawn or used as a blunt object. Does it mean anything else beside that in the other statutes or scenarios?
Madam Chairwoman, I'm not able to run down all of the cases that might have applied used, but I can certainly see the two examples you gave applying. I could even see somewhere that it's not sort of waved around or brandished, but used in the crime without maybe even showing it, right? Like in a sort of a concealed way. I'm putting my hand under my jacket for those that can't see me. Under the right facts, used could mean a number of things. If it's sort of in furtherance of the crime or aided you in the crime, right? Those are kind of the tests that you'd be looking at.
Thank you. Senator Haley.
Thank you, Madam Chair, and I appreciate Mr. Thompson bringing this up in terms of what used might be. I remember the discussion years ago. Senator Smith, former Senator Smith might remember, where the various classifications of having a weapon has different penalties. So used, I think, is too broad. I remember there was brandishing. There was actually showing that if one were aware that one had a weapon, showing it. Then brandishing is waving it or using it in what could be considered a threatening manner. And then, of course, discharging it is actually firing the weapon. And each of those had different levels of corresponding penalty. So I would hope that we could tamp down a bit on the word used. Discharged is obvious. Used is less so. Because if as Mr. Thompson examined, if you pull your jacket across and you're having a weapon, are you using it as a threat? Or so I'd like a little more clarity. Discharge is obvious, but brandishing and showing less so.
Thank you. I think there's some statements from the revisor that it's defined in case law. The purpose of the amendment was to address possessed is too broad, and that those who lawfully possess a firearm should not be penalized as they would be in the bill without the amendment. So, committee, further discussion on the amendment or questions? Seeing none, then we have the motion and a second. Then all those in favor of the amendment signify by saying aye.
Aye.
Those opposed, no. The motion carries. We're back on the bill. Committee, any further discussion, amendment, or what's the will of the committee? Yes, Senator Haley.
Thank you, Madam Chair. I heard the testimony on this bill, and I continue to harbor some underlying concerns about it. I won't be supporting the bill with or without the amendment. To me, I think it's a little bit overly broad, even though it is in statute, to enhance a penalty for someone who is, fleeing or eluding. There are examples around the country, certainly, fortunately not in Kansas, of someone in the capacity of fleeing or eluding. Let's just say law enforcement's response has been overly broad. And I think that there are significant penalties in place already for it. And to enhance that, it's just something that, especially for pedestrians or those that are pedestrians, as I said during testimony, it's a privilege to be licensed to drive a vehicle, and with that privilege comes the ability for law enforcement to stop and frisk and inquire as to where you are, what are you doing, what have you. But to have that, or to enhance that, even though it's in law already, and to enhance the penalty for being in your own space or your own time is just something. I think this is a call too far. Thank you.
Thank you. Committee, other discussion or questions? Seeing none, is there a motion to move the bill as amended favorably, or any other motion regarding the bill? Yes, Senator Wilborn.
Madam Chair, if I might, I'd like to make a motion to move Senate Bill 174 as amended out favorable for passage.
Thank you. Is there a second? Senator Gossage, thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, thank you for your attention working those bills. We do have a hearing scheduled for today. It is Senate Bill 240, so we will open the hearing on Senate Bill 240, amending the crime of aggravated endangering a child to increase the criminal penalties in certain environments where any person is distributing, possessing with intent to distribute, manufacturing, or attempting to manufacture fentanyl-related controlled substances. And with that, a brief bill brief from the revisor. Thank you.
All right. Thank you, Madam Chairwoman. Jason Thompson, Revisor's Office. Senate Bill 240 does amend the crime of aggravated endangering a child to increase the criminal penalties in certain environments where someone is distributing, manufacturing, et cetera, a fentanyl-related controlled substance. You'll recall from our discussion on Senate Bill 238 the other day that defining these substances is one thing that we need to do when we're talking about them. So you'll see the definition on page 2 of fentanyl-related controlled substance is the same that we used in that Senate bill. It covers a number of drugs that have fentanyl-related content and would make all of them subject to these enhanced penalties. I outlined in the bill brief kind of the current law, and I won't read that for you, but there's a crime of endangering a child. There's a crime already of aggravated endangering a child. And one of the things that can make aggravated endangering a child is the environment containing methamphetamine or materials used to distribute or manufacture methamphetamine. So those are current law B2 and B3. And what's done in the bill is to add fentanyl-related controlled substances to those same provisions that already cover methamphetamine. So this would raise the penalties from the current level, likely Class A person misdemeanor for just generally endangering a child that would probably cover this conduct in most cases, and would raise that to a severity level 9 person felony, just like the current law does for methamphetamine. So hopefully that helps clarify the what's going on in the bill here. I'll be happy to answer questions.
Thank you. Committee questions for the revisor? Seeing none, then we will ask, we have Mr. Todd Thompson, Kansas County and District Attorneys Association on WebEx. Please introduce yourself and welcome to committee.
Thank you, Madam Chairwoman. I hope that you all can hear me well. I appreciate the opportunity. Happy President's Day. Seeing it is I am Todd Thompson. I'm the Leavenworth County Attorney. I'm also past president of the Kansas County and District Attorneys Association. I am also their chair of the Legislative Committee. We stand here as a proponent to this legislation. One of the things I would start with, as I was saying, is Happy President's Day. Due to President's Day, I would like to say a quote from Jimmy Carter, who we know is now in hospice, and he said, the well-being of our children must be the national priority and responsibility of every individual. Obviously, you are individuals that can help make that a priority. One of the issues that I think everyone is well aware that's facing our country is the epidemic of fentanyl and how deadly it has been not only to users, but also families in general. I will say that we did have a death of an 11-month-old in our community related to fentanyl, just by it being in the area of or somehow consumed by the child, we believe. That's still being investigated, but it is a concern that we face in every county and every state that we do. And so we hope that this legislation will increase that penalty from just endangering to an aggravated endangering a child, such as methamphetamine has already done. I don't know if you have, and this might not be an appropriate time for this, but also within my testimony, one of the issues that the board and myself particularly have found with this the particular statute of aggravated endangering a child and endangering a child is one where a firearm causes harm to a child. We've had several in our jurisdiction and multiple in the state where a firearm is left in the area where a child could get access to it and actually has shot themselves. And right now the burden, or not the burden, but the penalty is a level 9 felony. It does not seem that would be severe enough for a harm that causes to the child. And we would ask or consider an amendment to also include that. But we are very supportive of Senate Bill 240 as it does stand. Thank you, and I stand for any questions.
Thank you, committee. We will ask questions of the conferees after we have heard from all three of them. Next, we will hear from Mr. Greg Smith, who is here on behalf of the Johnson County Sheriff's Office from my county, and he's the Special Deputy for Government Affairs. Please introduce yourself and welcome back to committee.
Thank you, Madam Chair. It's a pleasure to be here. I'm Greg Smith. I'm Special Deputy for Government Affairs for the Johnson County Sheriff's Office. This is a bill that we requested just because fentanyl is the thing that we're seeing more and more and more of. And we're receiving disturbing reports. The Northeast Kansas Drug Task Force, it's a 3-county task force, operates under the Sheriff's Office. We're running into situations where there's children present in these areas where they're manufacturing and getting ready to distribute this product. In my testimony, I mentioned the fact that there was a child that was 4 years of age during a controlled buy. I was incorrect on that. That's actually a 2-year-old child that was present during that controlled buy. As Jason told you in the bill explanation, this is current law. We're not changing anything other than adding fentanyl to one of the aggravating factors for aggravated endangerment of a child. That is all this does. Everything else is current law. Nothing else is changing. I will save the rest of my testimony and stand for questions at the appropriate time. We have a member of that task force that's going to be on WebEx testifying, and they can probably tell you about it better than I can.
Thank you. And that's a nice introduction to Mr. Mike Long, who is the Johnson County Sheriff's Office Northeast Kansas Drug Task Force. He's on WebEx. Please introduce yourself and welcome to committee.
Thank you, ma'am. I'm a Detective Mike Long with the Johnson County Sheriff's Office. I'm currently assigned to the Northeast Kansas Drug Task Force. For you that don't know, that's a multi-jurisdictional task force. We investigate drug activity in Johnson, Franklin, and Miami counties. In the past several years, the task force has seen a significant rise in the distribution, use, and abuse of fentanyl in our area. Through our contacts with other agencies in Kansas, we know that this is a trend that is occurring throughout the state of Kansas. During our investigations, it has become more common that children are present where fentanyl is being distributed, stored, and consumed. We believe that adding language to the current statute that includes fentanyl would assist prosecutors in holding people accountable for allowing children to be present in such dangerous situations. I have a few examples of situations that we have run on just to give some context to why we're asking for this. In 2020, the Marion Police Department and our task force investigated the death of a 2-year-old child that inadvertently ingested a counterfeit tablet that contained fentanyl. That child's parents and their drug dealer were ultimately charged with various crimes associated with that child's death. Now, moving forward into March 2022, the Shawnee Police Department and our task force investigated the overdose of a 10-month-old child. The child was transported to the hospital where the child tested positive for fentanyl. The child did live, but during the interview with the parents, it was determined that the parents were heroin addicts and that their heroin was laced with fentanyl. The child most likely ingested the heroin fentanyl combination while the parents were consuming drugs in the child's presence. The parents were initially charged with aggravated endangering a child, but those charges were later reduced or amended by the prosecutor's office because they didn't meet the statutory requirements for aggravated endangering a child. In November of 2022, the task force, we were conducting several controlled buys of fentanyl from a subject in Olathe. During those controlled buys, the drug dealer had their 2-year-old child present during the investigation. The drug transactions took place at the kitchen table that appeared to be used by the family. Detectives quickly executed a search warrant at the residence. And when we did that, we located the child sitting next to several pieces of drug fentanyl paraphernalia. The father of the child was passed out at the kitchen table after he had consumed fentanyl. The parents were charged with aggravated endangering a child only because there was also methamphetamine that was found in the house. It is our opinion that the fentanyl was more of a danger to the child than the methamphetamine was at that time. In just this month, we also conducted another series of controlled buys from a person selling counterfeit tablets that contained fentanyl in Shawnee, Kansas. Once we executed the search warrant, we discovered that a 1-year-old child was living in the residence. The parent and the child shared a room which contained the fentanyl and where a gun was also being stored. The child very easily could have consumed some counterfeit tablets if they'd come in contact with packaging or any type of material that contained fentanyl residue. We believe that changing this statute to include fentanyl will assist law enforcement and prosecutors in holding people accountable for knowingly placing children in such dangerous situations. Thank you.
Thank you. Committee, questions for the proponent conferees? Seeing none, I want to thank our Johnson County representatives for bringing this to the legislature's attention, Mr. Greg Smith and Mr. Mike Long, and for the Kansas County District Attorneys Association for speaking on this as well. Thank you, Mr. Todd Thompson. Committee, you do also have written only proponent testimony from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association of Chiefs of Police, and Kansas Peace Officers Association, and want to thank them as well for bringing this to committee. Are there any other proponent, neutral, or opponent conferees in the committee meeting room or on WebEx? Seeing none, then we will close the hearing on Senate Bill 240 and thank the conferees for their attention and their testimony in committee today. With that, then, committee, since Senate Bill 240 is fresh on our minds, I'd like to work Senate Bill 240. Do we have, I don't think we have a need for a brief from the reviser since we just heard the bill. Is there a motion regarding Senate Bill 240? We'll stand at ease just a moment. Committee, we're going to backtrack for just a minute and go to the bill we were working earlier, Senate Bill 238. 238 increases the criminal penalties on drug-related crimes when the drug is fentanyl. And that bill was not amended. Do we have a motion regarding Senate Bill 238? Senator Wilborn.
Thank you, Madam Chair. I'd like to make a motion to move the contents of Senate Bill 240 into Senate Bill 238, since they are both fentanyl-related pieces of proposed legislation.
Thank you. And we have a second from Senator Baumgartner. Any discussion on the motion? Seeing none, would you all have heard the motion? All those in favor signify by saying aye. Those opposed, no. The motion carries. Do we have a motion on Senate Bill 238 as amended? Senator Wilborn.
Thank you, Madam Chair. I'd like to make a motion that we move Senate Bill 238 as amended with the contents of 240 out, favorable for passage.
Thank you. And a second from Senator Baumgartner. You all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we are working hard today. Appreciate your attention. We're going to next turn our attention to working Senate Bill 217, which includes the conduct of utilizing any electronic tracking system or acquiring tracking information to determine the targeted person's location, movement, or travel patterns into the crime of stalking. So if you use a personal or a private tracking device, that would be included in the anti-stalking legislation. If we could have a bill brief from the reviser.
Thank you, Madam Chairwoman. Jason Thompson, Revisor's Office. So this is the bill about unlawful tracking devices, as you just heard. You'll recall that there's an amendment to the stalking statute. So this would be a criminal offense in some cases. There are also amendments to the family law code to add this as conduct that's not allowed under certain protective orders in that code, as well as the Child Need of Care Code and the Protection from Abuse Act and the Protection from Stalking Act.
Thank you. Committee, questions, discussion, amendments? Yes, Senator Wilborn.
Thank you, Madam Chair. I do have an amendment. Mr. Thompson, would you please distribute it and explain the amendment? Some are technical, some aren't.
All right, thank you again, Madam Chairwoman. So this is the amendment that was discussed in the proponent testimony. We realized in reviewing the bill that we missed adding this provision in one section that was already in the bill, and then another section that was not in the bill that probably should have been. So you'll see we add a statute to the title on page 1, and we'll talk about that in a moment. And then on the bottom of page 3, you'll see that we insert that statute. Again, we'll get to that in a moment. And then on the top of page 4, in the current law that's in there, KSA 23-2707, these are permissible orders under the Family Law Code. The bill attempts to add this to subsection A1, dealing with property, but it probably should also include it in A2, dealing with restraining the parties from molesting or interfering with the privacy or rights of each other. So the same provision that's in subsection A1, right above it, would be added to A2, same language. All right. And then the new section that we realized probably should have been added is also in the Family Law Code. So you'll see on the final page of the balloon amendment, there's an attachment A. This is KSA 23-2224. This is part of the Family Law Code, specifically the Parentage Act. And in that section, the court is allowed to make certain orders. One of them restrains the parties from molesting or interfering with the privacy or rights of each other. And this would add the same language, including but not limited to utilizing the tracking devices. So in some ways, just kind of an addition of 2 more places we identified that the same language would probably be added if you wish to enact this policy.
Thank you. Committee questions. Is there a motion on your amendment?
Thank you, Madam Chair. I so move the amendment.
Is there a second? Senator Baumgartner with the second. Committee, you all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. We're back on the bill. Senator Wilborn?
Yes, Madam Chair, again, I'd like to make a motion to move Senate Bill 217 as amended out favorable for passage.
Second from Senator Baumgartner. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we are hearing a bill tomorrow, Senate Bill 243, and also would like to work bills previously heard with attention to Senate Bill 232, establishing the Office of the Child Advocate as an independent state agency. So I had heard that there were some possible amendments, so please have that ready to bring to committee tomorrow so we can work Senate Bill 232. With that, I want to thank everyone for their time and attention, committee members, as well as those following along online in the committee meeting room, and our staff. Thank you very much. We are adjourned.